All right, now, Chris, here's the biggest one, I think. And this change really is what the legal aid people and the tenants lawyers are up in arms about. And I think, you tell me, Chris, does this destroy due process of the tenant? Okay, but here it is. The landlord now has the option to get an eviction without a trial. Welcome to episode 103 of the Weekly Document, a podcast by the Sullivan Law Firm where we talk legal news and practical law. Today is January 2nd, 2026. I'm Phil Silberman, owner of the firm, and your host, and I'm joined by Chris Hield, who is our supervising attorney at the firm. Chris, you came back for another year, so you feeling good about it?
I did. I'm glad you're having me back for another year. I guess it works both ways.
Hey, how about that Ole Miss upset last night? What'd you think about that?
I thought it was an exciting game. I'm glad after the first two games we got an exciting one. I'm not shocked, but I certainly would not have picked Ole Miss either.
I thought the win probability thing was cool. That was the first time I followed it. And if you watch the entire game, at the point of the Ole Miss fumble, the chances of Ole Miss winning went down to 50%. And then at the very end, and I want you to explain this to the listeners because I was thoroughly frustrated. It was a good game. And then there was the second to the last play of the game where the lateral that ended up being a safety, and then so 2 extra points, right? And the announcer, then they bring the game's over, allegedly. They bring the whole stage on, and the referees are like, we reviewed it, 1 second left on the clock. And I'm sitting here, really? We don't need to do this. But the announcer made a comment. He said, that's a safety and that's 2 points. So that changes the margin. That matters for some people. Chris, can you educate our listeners on who those some people are that might care about Ole Miss winning by 3 points versus 5 points?
In this case, those some people are the true degenerates of all degenerates because you would have to be live betting for that to even matter because the spread on the game was 6.5. Ole Miss easily covered that. And the over-under was like 55. So it went way over. So unless you live bet in the third or fourth quarter to add money, no, I think this is going over 72. That didn't mean anything to you, but I suppose there are definitely people out there live betting the over 72.
Okay, so you educated me. I did not know you would have to live bet for that to matter. But the announcer obviously knew, but just can't be that crass on television. And I'm glad he's not, because I'm sitting there watching it. It's late and I'm watching it with my 11-year-old. So I'm glad the announcer did not have to explain the live betting phenomenon. But our listeners include, and I'm more educated because of that explanation. So thank you, Mr. Hild. I appreciate that.
So this all started several years ago, whether it was like Al Michaels or Brett Musburger or one of those guys who said that last touchdown is significant to some. Like not significant to the casual fan, but it is significant to some because yes, oftentimes the Vegas line is very close to spot on. So points one way or the other could make a cover or break a cover.
Okay. So this referencing the sum out there it has been a thing for a while. All right.
Yeah.
There you have it. All right, Chris, we were talking about what's on our docket today. We have one thing to do, and we're going to try to do it well. And you had not heard about this, but this is big news. If you turn on any kind of local news or anything out there about the law, everybody is just absolutely screaming about these changes to the eviction proceedings and how we evict people in Texas. I obviously own the law firm. We do evictions. My management company does a lot of evictions, and when there's pressure on consumers, we do a lot more evictions. And Chris, there are pressures on consumers right now. All my friends that own properties and all the landlords out there and tenants' rights lawyers and legal aid, everybody's talking about this. So let's just go ahead and get it kicked off with this one thing we're doing, explaining the changes to the eviction law. This is Senate Bill 38. And these changes went into effect yesterday, Chris, on the 1st, on New Year's Day. And what they do is they attempt to streamline the eviction process and standardize proceedings across the state. And then it also addresses squatters, which we're going to talk about squatters at the end of the show. But
I was going to guess it would have to address squatters because that's been a hot topic for last half decade.
Yeah, and we're going to talk about it, but really it's one of those things. What's the odds of you really having a squatter in your home? When it happens, it's terrible. There are people out there that have this happen, but that kind of garners all of the news, but it's rare that someone comes back from vacation and hey, there's people in their home. But we wanted to address that because we're Texas, but really the statistics here, and if you think about what you're going to die of, all the things you're going to die of, Chris, it's what colon cancer and car accidents for guys our age. The odds of dying of something else probably pretty slim. Let's talk about, Chris, what is most likely to kill us, or at least what we're most likely to deal with when we're dealing with evictions, and that's some of these changes on just non-payment of rent evictions. And Chris, by the way, I want to point out this covers both commercial and residential tenancies. All these changes are in the property code. It's chapter 24, which is going to apply to both commercial and residential. So let's do the first one. This is a interesting one. Tenants are now barred. Okay, you're not allowed. If you're a tenant and you're sued for eviction, you're now barred from bringing a counterclaim or joining other third parties. I'm going to read you the language real quick, Chris. So your counterclaims and the joinder of suits against third parties are not permitted in evictions. This subsection does not preclude a claim that may not be asserted under this subsection from being brought in a separate suit in a court of proper jurisdiction. All right, Chris, here's what I want to ask you. I need you to use your brilliant lawyer mind. Does that mean if I'm a tenant and I haven't paid rent and the landlord sues me for eviction, but I'm not paying rent because the landlord hasn't fixed my air condition or hasn't fixed my roof, does that mean I cannot bring that counterclaim or not bring that assertion in the eviction hearing? What do you think?
I would think that would be a defense.
Okay.
I thought we've had cases where we have cited to courts that the only thing that can be heard in an eviction is the eviction. I never thought you could bring counterclaims. Is this a change or is this just spelling it out?
It certainly spells it out. I'm with you. This idea of you're suing me for eviction on non-payment of rent, but you don't win because you haven't fixed the roof is not a counterclaim. It's a defense. I'm with you on that, but I'm wondering how this gets interpreted. But Chris, here's why I'm with you. There was a Texas Supreme Court case that's very famous. We talk about Rumos, and it was really known for attorney's fees, but it's really known for this idea that the payment of rent is no longer an independent covenant in the contract to pay rent, right? Rumos basically said, aside from the whole attorney's fees things, yeah, the landlord is owed rent, but the landlord didn't fix anything and recognize that for the landlord to recover, the landlord has to meet their obligations, and no longer can the landlord say, I don't care what I haven't done, pay me rent, we'll talk about the rest later. That was a big Rumos thing. That was the name of it. Do you remember that, Chris, at all?
Yeah, no, that's like getting rid of the last remnants of caveat emptor.
Yeah.
Like really oppressive law that, okay, I rented you a space. Sorry if your stuff breaks or sorry if there's rats. That's your problem. You rented the space. We are miles away from that.
But Rumos, that case changed 100 years of law of rent being an independent covenant. Reading this on its face, enterprising landlord lawyers may attempt to persuade a JP court judge who are usually not attorneys, Chris, say, oh, the landlord's sitting over there complaining I haven't fixed it. The landlord hasn't fixed this, the roof, the HVAC, the water heater. Oh, judge, all that doesn't matter now because you see this brand new law that just came out says no counterclaims. So a JP court judge might fall for that. Chris, we don't usually represent tenants, but if you were representing the tenant, I suspect the argument would be, no, judge, this is a defense, it's not a counterclaim. You with me on that, Chris?
Yeah, for sure.
Okay. So I think that's a big one. Let's move on to the next big change. And this seems like a little thing, Chris, but it's a big thing if you're a volume landlord or you own an apartment complex and you do a lot of evictions, okay? Notices to vacate. Wait for it, Chris. Here it is. Notices to vacate may now be delivered via email if the tenant has agreed to this method in the lease. Okay. So that is great because, again, if you own an apartment complex management company and you're doing hundreds of notice to vacates a month, then all of a sudden, those certified mailings, which are now what, 6, 7, $8, Chris, you're saving all that money and you're not having to stuff envelopes and you just send it via email. Now, Chris, here's what I'm gonna read you the code, okay? This is a 24.05F-3. This is the change. It says if the parties have agreed in writing, electronic communication, including email or other electronic means. That's the relevant section, okay? Now, my question, Chris, is the lease, the standard lease that we all use, the Texas Association of Realtors lease. There is a notices provision in this lease that we've been using for years and years. And here it's just this general notice provision. All notices under this lease must be in writing and are effective when hand delivered, sent by mail, or sent by electronic transmission. And then it tells the tenant, don't include an email address there unless tenant, Mr. Tenant, you consent to receive notices under this lease by email. But Chris, it doesn't specify notice to vacate. So the code, going back to the code section now, it just says if the parties have agreed in writing, electronic communication, or email, and it's referencing a notice to vacate. So, Chris, the first thing that they did over at the realtor's office, the Texas Association of Realtors office, when they saw this coming, they amended the TAR lease to specifically say, Mr. Tenant, you agree for notice to vacates being right. Chris, what do you think? I think this is enough. I want to start doing notice to vacates solely electronically for all of my tenants using previous leases, because it says a general notice provision doesn't specifically say electronic by notice to vacate. And then,
Yeah, but that wasn't the law at the time. So at the time they agreed to that, they couldn't agree to electronic notice to vacate. So I don't know if that's going to fly. Is it going to fly today if everybody's still using the same, the management companies that still have the same forms, that aren't printing off new ones, that aren't going to look at the 2026 revisions? If they use that, they have a better case for anything entered into 2025 and before, provided you make the argument, because remember, when you go to court, you have to actually make the argument. But if you made the argument, hey, that wasn't the law at the time, I couldn't have consented at the time, this isn't going to adjust my rights later, I think the judge would say, yeah, you got to give notice the old way.
The judge is going to be sympathetic to it. Okay. I'm glad you sobered me up on that. I still may try. I guess I'm a scumbag property management guy or landlord because I really want to save all this money and time on notice to vacate. I might give it a shot on a couple and just send them the notice to vacates via email when they're under the old. Now, this is no longer a problem in a couple years after all the leases have cycled through.
Right.
And we're now using the TAR lease. But if you had a client come to you and you say, hey, I sent an electronic notice to vacate, you'd caution the client that may not be good under the old lease. Okay.
Yeah. As we always discuss, I don't like showing up to court and being told I did something wrong. Even if the client told me, no, I did it, I'm sure I'm right. I'll send the notice. I want it to be my notice. I want it to be the form I sent in. Just minimizing problems, because going back to court after you got nothing done the first time is a pretty bad feeling.
Yeah. All right, now, Chris, here's the biggest one, I think. And this change really is what the legal aid people and the tenants lawyers are up in arms about. And I think, you have to tell me, Chris, does this destroy due process of the tenant? Okay, but here it is. The landlord now has the option to get an eviction without a trial. And it's a summary disposition, and here's how it works. The landlord so you file your eviction petition, and then you can simultaneously file a sworn statement, okay, alleging that there's really no dispute of facts, the tenant owes me money, and it's an open and shut case, paraphrasing, right? But effectively, sworn statement, and then what happens is the tenant gets served with the eviction lawsuit, the petition, and the sworn statement. And then the tenant has 4 days, okay, after getting served with the petition and the sworn statement to file a response, basically disputing the facts and alleging that there are, in fact, disputed facts. Now, Chris, knowing what you know about tenants, residential tenants, let me start with this. How likely is it, do you think, a tenant that gets a eviction petition and a sworn statement is going to be sophisticated enough to file like a response a within 4 days with the court disputing those facts? How likely do you think that is?
I don't know. You might be surprised about my answer. I think all of them will because it's a fairly liberal pleading standard, and especially in JP court where they just have the forms right there for you.
Yeah.
So really all you have to do is go pick up the fill in the blank form, take it to the window and say here.
Okay.
And I don't know what standard's going to apply here, but when people are being evicted and they don't have anywhere to go, they will take advantage of the system. And ironically, this is what this is trying to avoid. This is trying to avoid the people who just truly have no defense. You didn't pay rent. I'm sorry you had medical bills, or I'm sorry you lost your job. That doesn't change the fact that you didn't pay rent. And then they demand a jury trial. They drag it out. This is meant to avoid that. I get it. But those same people are the ones that they're hanging on. If you were going to be put out of your house, you'd do everything you could to stay in. And so
Yeah.
I think they'd probably find their way down to the JP annex and they file the document they need to file.
And I want to point out the landlord statement of there being no disputed facts is a sworn statement. That's a jurat. Okay. In the code, it just says the tenant has to file a response. It doesn't say the tenant has to go out there and prepare an affidavit, which is a sophisticated thing. So that may be with purpose. The tenants bar may have got a victory on that one. Chris, you think the tenants will do it? You don't think they'll figure this out and the tenants will know,
Yeah, 'cause I think the citation is going to direct them on what they need to do. They show up at trial. I think what they're trying to do is streamline it for the landlords, for these tenants that drag it out. Like I said, they demand a jury or they ask for a continuance, and then they show up at trial and they just say, Judge, I lost my job. I really want the landlord to work with me. True as those things may be, that's not a legal defense. And so we're trying to just shortcut all that. But when they get a notice of a date and time of a trial, they show up.
Okay.
By and large. Not every single one of them. And
We'll see how that plays out. According to your take on it, you don't think this is going to be that material. The thing that concerned me most when I read it, I was like, does this really have any teeth? Let's say the landlord files a sworn statement and the tenant just doesn't respond, right? You would think that it's a high likelihood the JP court is then going to just rule in favor of the landlord, wouldn't you?
I would think there's a pretty good chance, yeah.
In the code, it's permissive. It says the justice courts may enter a judgment regardless of the tenant's response. Okay. So how many JP court judges out there are going to just throw the tenant out if they don't file a response? That's my question. Maybe some.
That's a good point, especially until this gets some history behind it of how it's been applied. There's any clarifications on it. I think it's going to really have to be the extreme cases first. Judge, this person is 6 months overdue. They're just not paying. It's an apartment complex where there can't really be any dispute as to title or anything like that, and see if it gets some traction, see if these JP judges are willing to implement.
Yeah, we'll have to see about that. There was a provision here, Chris, that I don't think a change that I want to talk about real briefly that I don't think made it in. There's sort of some confusion on it, but the landlord bar wanted a change to the law that would have allowed the landlords to change venue to an adjacent precinct. And can you imagine why that would be significant? Just thinking about politics. Let's say you're a landlord and you own an apartment in downtown Dallas, okay? Do you think the precinct in downtown Dallas tends to be a little bit more blue than red?
Yes.
So if you can file a motion to transfer venue to the adjacent precinct and get out of downtown Dallas, that's going to be very favorable to landlords, right?
Yeah. Is it if you're in one, you go to two? If you're in two, you go to three? Or is it like you get to pick any of the touching?
It's got to be any adjacent. It was anything touching. Now that I do not think that made it. All right. Because
I would think, yeah, you need to file in the precinct for the property.
That's the original jurisdiction, but I think that still is the law. Chris before the show was like, Phil, I was very late because Chris was like, do we need to reschedule? That's what was causing me all this grief because the AI thought the change made it, and there was all these versions of the bill that had it in it. And then I went and checked Westlaw, Chris, currentness of the bill. And it did not have it in it, but it was hard to say, but maybe did Westlaw miss this? But I don't think it made it. I think it's just original precinct where the property is located, original jurisdiction, you don't get to move it. But that would have been a big change. But for if you're a tenant guy out there, you're friendly to tenants, I think that saved a lot of grief for you.
If you're the landlord, you chose to purchase the property. You knew where you were buying this dog.
I
Like, oh
know.
no, horrible venue. Like, you chose to do business there. You get to do business there.
I know, but hey, let's just say there are certainly some unfriendly precincts out there, Chris, that I would love to have moved over to the precinct over. All right.
I think it's good enough that if we're the landlord, we can file evictions in whichever place we want. So if you receive an unfavorable ruling, or we've had notice issues where some judges are just extremely strict on notice and they say, your notice doesn't comply, and they don't tell you how. They just tell you it doesn't comply. So we say, oh, maybe we go try the other place in this precinct. If
a big part of these changes on the notice to vacate was meant to resolve some of those crazy technicalities on the notice to vacate that the tenant-friendly JP Court judges were using. All right, we got to move on. This is the last thing. Chris, they carved out basically another section. There's 24. We've been in Property Code 24 talking about all these changes. Now, and this is all 24B. And the title of this chapter is Removing of Certain Unauthorized Yada Yada. Removing of Squatters is what this, I'm paraphrasing again, but this is removing of squatters. And basically, the way these changes work is if you're that guy or you're the property owner and someone just shows up at your property and starts squatting, as long as the property was not open to the public, I guess it wasn't, I don't know what that means. You weren't like a restaurant or something. I don't know. And there's no pending litigation, and you're not and the squatter there was not a current or former tenant or some kind of owner, not an immediate family member. It can't be your 20-year-old son. Okay. As long as it's not any of those. And this is a due process thing. Tell me if you think this is a due process thing. Chris, you can skip the whole court process altogether, and you can just fill out this sworn statement that basically says, I'm the owner of the property. It's got to be residential. I don't think this applies to commercial, but it's got to be residential. The person unlawfully entered and it wasn't open to the public, all this kind of stuff. And then the sheriff or the constable can basically just go down there and arrest the person. That's what we're doing now. You like it, Chris? Don't like it?
Do they have to show any kind of proof of ownership or just their sworn statement?
They have to show just the sworn statement, and then the law puts it on the sheriff, okay, to make this verification. The sheriff has to verify who the record title holder is. Now, if you know nothing against law enforcement, they're great people. I love law enforcement, but they're often not the most sophisticated guys in the world. I don't know how the sheriff or constable is going to have to hire some kind of in-house counsel. They're going to have to get help from some sort of county attorney, I presume. Because the obligation is now on the sheriff to verify the record owner of the property.
And I imagine it's still permissive. It's not going to be like a writ that the judge says, do not fail to execute this writ.
No, I think it is like that. They've got to verify the record title holder. And then upon verification, it says the sheriff or constable shall, this is not permissive, shall, without the owner's consent, and basically put the owners in possession of the dwelling, and they've got to serve notice on whoever's there, and then they can basically go out and arrest them, I think is what's going on.
I wonder if it's similar. Does all this happen similar to a writ of possession where the writ gets issued, you get served with the writ, the constable gives you a couple of days. That way you can run down and try to get an injunction.
Yeah, there may be that component to it. Or the sheriff gets a fee equal to the amount of a writ of possession, and then the sheriff serves the notice. And then the mechanism, let's say you were a squatter in there and you wanted to counter this, I guess you would have to go file in the district court maybe for an injunctive relief, I think is how that would have to happen. It's a little unclear.
Yeah. I like the idea of getting squatters out. It's just, we see everything. And unfortunately, I think this would be misused. And you and I talk about this all the time. We have cases, they just will never go away. People just think contracts for deeds are still the greatest thing. People still do them. And so I just see a lot of abuse on that front with people saying, hey, I'm the owner, I have the deed. And then the other person saying, but I have the right to buy it. And they're just not letting me buy it. And I have a contract right here that says I can buy it. And if you have a constable come and take them out
Yeah.
and say, I've got a sworn statement that says it's their property, and you seem to be acknowledging it's their property.
And I want to interrupt you a second, because in your situation, in your fact pattern, which is an excellent fact pattern, that contract for deed is not necessarily determinative of the record title holder. So the sheriff could be sitting there. You're effectively asking the sheriff, what's the sheriff going to do? I guess they're going to call the county attorney, counter attorney. They're showing me this document that says contract for deed is not recorded. What do you have in the real property records? And the county attorney is going to be like, I ran a title search. We've got that owner. Forget about it. Pull them out. Even though that contract for deed could reference some sort of legal title interest, or at least we're asking the sheriff, we're basically asking the sheriff to be the judge, the jury, and the executioner, like all at once. So that's what I mean. What do you think, Chris?
That's why they hate it. That's what they don't want. That's why they always say, this, they say to us all the time, that's a civil issue. I want to go arrest drug dealers and murderers. That's a civil issue. I'm not about to get involved in your dispute.
Well, they're involved in it right now, whether they like it or not. And I think they're woefully unqualified to be involved in it. So the sheriff's office or the constable's office is going to have to hire a real estate attorney or use the county attorney or however that works. So.
Yeah, I like the ideas behind it. Unfortunately, like you were saying earlier, it's the 1 in 10,000 case that gets all the publicity. That's what we're trying to stop. The person who sneaks into your house, changes the locks, gets a water bill and a light bill in their name, so that when the cop shows up, they say, no, here's my water bill. This is my property. And that the cop says, look, this guy's got utilities in his name. I'm not going to force him out.
Chris,
you got to take this to eviction.
But I'm going to tell you, I think we end up using this, Chris. When we get owners calling us and there's somebody there that's on some kind of bogus right of possession, this is not a bad chance to get the guy out without any kind of hearing. If you can get the sheriff around, it does create liability. It does create liability, and it specifically says that this law is creating some type of wrongful removal cause of action if you do wrongfully remove somebody. So
yeah, that's got to be pretty significant, because I can think of nothing more disruptive and harmful to a family than kicking them out of their house and on a moment's notice.
Yeah, if our clients pay enough, Chris.
But we're usually the ones on the other side. Think about how often we're on the other side. There's a title issue that our people take control of the property, but the title issue was never cleared up, so title never properly transferred to them, or the contract for deed scenarios. So we find ourselves far more frequently on the side of the person who's doing everything they can to exercise their rights, but the quote unquote owner didn't do something right or is being shady and prejudicing our clients.
Yep.
So I worry about it from that side a lot more than I worry about the house we have 2 streets down, that there was a news case about it, that I think it was either listed for sale or the people were on vacation and squatters absolutely moved in, changed the locks, got the utilities in their name. Like, those are bad actors. The people we represent are people who are just trying to fulfill the terms of an agreement and are being told by the other side, who is the bad actor, that they're the ones in the wrong.
Yeah, and I think you're right. We'll be on the other side of this probably a lot, where we are filing in district court for injunctive relief to stop the sheriff from removing the person. All right, that brings our show to a close. I've been your host, Phil Silverman. Chris Hill has been my co-host today. This follows for us wherever you get your podcasts. And as a reminder, nothing in this show is being considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com, info@silblawfirm.com, and tell us you want it publicly answered in the podcast. Everybody have a happy new year.